Good afternoon, and thank you to everyone in attendance today. We're really looking forward to listening and to learning and to engaging in what I'm sure will be a dynamic and powerful discussion about the intersections of race and citizenship and the way constructions of both are weaponized through intellectual property law to perpetuate really an inherently inequitable society. Before we introduce our guests and dive into tonight's discussion, I would like to take a few minutes to introduce the New England Law Review and to acknowledge the energy and the efforts of the entire staff of Volume 55 this year. The New England Law Review has been an entirely student-run publication since 1965. We publish thought-provoking legal scholarship written by both professional and student authors. Our work has been cited widely in both state and federal cases, providing insight and analysis for judicial opinions, other law review articles, bar journals, and appellate briefs. This year, we came together as a team to continue our work, despite an unrelenting barrage of challenges. This year has been difficult, to say the absolute least. For so many, this year was and continues to be simply about survival. Like everyone in attendance today, our journal members have had an incredibly difficult year. From the devastating losses stemming from the pandemic to the visceral impacts of a country struggling to reckon with a history of racism and white supremacy, it is often felt impossible to continue on with life as normal. Life continues to be anything but normal. Being a law student, and particularly a law student on the Law Review, carries with it its own unique challenges and burdens. I want to thank the entire New England Law Review staff for all your hard work and your commitment to the journal. But more so, I'd like to thank you all for your humanity this year, for your compassion, your understanding, your flexibility. I've been struck by your individual grit and your perseverance, but I have been overwhelmed by your commitment to spreading kindness and cultivating an environment of mutual care and support on our journal. Thank you to everyone who has prioritized uplifting one another throughout this year. Thank you to the executive board for being an exceptional team. Bettina, Maya, Julia, thank you for the ways you have shown up and stepped up and tolerated me this year. Thank you for sharing in a vision to engage in tough discussions and a commitment to leaving the journal better than we found it. Special thanks to Bettina, our executive online editor, for finding this book, The Color of Creatorship, which will be the root of our discussion tonight. Bringing this kind of conversation to New England Law Boston is something we are incredibly proud and excited to be a part of. I would also like to congratulate our incoming e-board, to Kyle, Navin, Claudia, and Caroline. We feel so relieved to be leaving the journal in such capable and caring hands in exactly 56 days, 22 hours, and 53 minutes. We cannot wait to see where you take the New England Law Review next. To our editorial board, thank you. Your roles this year took on a different shape than ever before, and you have been exceptional in your willingness to rise to the occasion. You have gone above and beyond to ensure not only that our journal continues functioning mechanically, but that our members feel welcomed, included, and valued. Thank you for stepping so seamlessly into mentorship roles when it was needed of you. To our associates, you are so close to the finish line of your first year. I am in awe of all of you, and I will forever be impressed by the way you managed to step into an intimidating and challenging world with care and with confidence. I hope you have found this experience to be rewarding, but at the very least, you should be incredibly proud of all that you have accomplished this year. Joining the journal is extremely challenging in the best of times. This year was simply unlike anything we've ever experienced before. You're incredible, and you should know that. I'd also like to thank Professor Varyani, a New England law professor who not only brought the first critical race theory in the law class to our school, but who has graciously agreed to help moderate tonight's discussion. She's also been unofficially named as one of the warmest and most supportive professors at our institution, and we thank you for that. Finally, to our academic advisor, Professor Friedman, thank you for your unfailing faith and confidence in our abilities. Your constant encouragement, your support, and your sharp and biting humor has helped keep us afloat during an otherwise incredibly difficult year. Go easy on them next year, okay? And now I'd like to provide a very, very warm welcome to all of our guests and our panelists this evening. We cannot thank you enough for joining us tonight, for sharing your insight, your perspective, your experience, and your expertise. We are really grateful to be able to learn from and learn with you. I'd like to first introduce Professor Anjali Vats. She is the Associate Professor of Communication and African Diaspora Studies at Boston College and an Associate Professor of Law at Boston College Law School. She is interested in issues related to race, law, communication, and popular culture, with particular focus on intellectual property. In her book, The Color of Creatorship, Intellectual Property, Race, and the Making of Americans, she examines the relationship between copyright, patent and trademark law, race, and national identity formation, all of which will be the topic of our discussion tonight. I'd also like to welcome Deidré Keller. She is the Dean of Florida A&M University College of Law in Orlando, Florida. Prior to joining, she was the Associate Dean for Academic Affairs at the Ohio Northern University Claude W. Pettit College of Law, where she taught for 10 years. Sorry, Deidré Keller. Deidré Keller writes at the intersections of intellectual property, personhood theory, critical race theory, and the Constitution. I'd also like to welcome Professor Osei-Tutu. She is an Associate Professor of Law at Florida International University College of Law, South Florida's public law school, where she is the Associate Director for its Intellectual Property Certificate. Her scholarship focuses on the relationship between trade-related intellectual property, human development, human rights, and culture. So welcome, all of you, and thank you so much for your time and for your energy tonight. I would be happy to mute myself, turn it over to you three just to introduce yourself, your work, your interests, and then we will turn it over to Professor Vats to talk to us a bit about her work and her book. Thank you. I should helpfully tell you in order. Professor Vats, if you'd like to say hello and introduce yourself first.
Absolutely. I think you hit the nail on the head there. I am an Associate Professor of Communication. I also teach in African and African Diaspora Studies. My appointment is split between those two departments, and I have a courtesy appointment in the law school where I teach about critical race theory. I teach all of the classes I teach are about race. So I teach about Black popular culture. I teach a class called Reading Race at the Millennium. I taught a class last semester called Joy, Activism, Justice. Just a lot of transformative justice questions, a lot of race and law questions come up in my work, my research, and my teaching. So as you know, I am also interested in race and intellectual property, which is what we're going to be talking about today. And I will tell you more of that story when we start talking about the book.
Thank you. Deidré Keller?
Hello, it's such a pleasure to be with all of you this evening. I'm Deidré Keller, and as you said, I'm the Dean at Florida A&M University College of Law. I actually just got here in July. I'm told I can keep saying I'm new for 3 years, so I'm going to ride that as long as I can. But I actually am new, just starting on July 1st, and came here from Ohio Northern after 10 years there. In the interest of full disclosure, I will tell you guys, Professor Vats and I have known each other a long time, 18 years, in fact. We were in the same small section at Emory Law School all those years ago. And she and I have been talking race and IP for many years. And so it's a pleasure to be able to talk race and IP with all of you this evening. Thank you for having me.
Thank you so much. And Professor Osei-Tutu?
Good evening. Thank you so much for having me here. So I teach at Florida International University, as you said, in Miami. I direct the intellectual property program, but I'm also the editor-in-chief of the African Journal of Legal Studies, which I just thought of as Professor Vats was speaking about her work with the African Studies program. And I also sit on the steering committee for our African Studies program at FIU. So I'm really excited to be here because although I don't characterize my work as being about race and IP, there's so much in what Professor Vats wrote about that does connect to my work. And in particular, I write about Indigenous knowledge, traditional knowledge. I write about IP, particularly from the international space, and also about human rights and IP. So there's a very strong connection there, and I look forward to the conversation later. Thank you.
Thank you so much. And Professor Vats, I will turn it back over to you. Oh.
Okay, I got the mute button under control here. Thanks so much for that lovely introduction. I'm going to do a few more thank yous. I just want to take a minute to express my gratitude to the New England Law Review for hosting this forum and for inviting me to be part of it. I am absolutely thrilled to be able to join these amazing IP scholars in conversation. And as you know, Dean Keller has already spilled the beans about our friendship. 18 years, I was not keeping count, but I guess we're counting. But yes, it's been a long time and it has been a really incredible journey. I'm going to talk a little bit about it in telling some of the genesis story of the book. Thank you to Natasha Varyani, to Brie Mainiero, and the staff that makes this event run. It sounds like you have a great collaborative team. It is great to see that, and it's great to hear that you were able to find a productive space in this really difficult moment. I want to say thank you to the respondents who have invested their time and labor in this conversation. Both here and in the print conversation, I hate to create work for people, and I very much appreciate the effort here to have this conversation. And some of these folks are doing double time, which is pretty extraordinary. So thank you for that. I owe you many Boston College coffee mugs, and I hope we can have a good conversation today. So thank you particularly to Dean Deidré Keller, to Professor Janewa Osei-Tutu, to Professor Kaylee Murray, and to Professor Sonia Cattell, all of whom will be participating in some form or another in this forum. I think it's really amazing as well to be able to join a panel with this many amazing, brilliant women of color. And so I want to flag that. This is not what I remember from law school. So it is nice to be able to be in this space and to be in a space where, you know, these conversations are not new to people, and also where we can develop some of those ideas. I also, before I jump into talking about the book, I want to bring a practice that we use often in communication and related disciplines of land acknowledgement into this space. We're talking about race and colonialism today, and so I want to call upon the work of Indigenous scholars and activists to recognize that histories of settler colonialism mark these stolen lands upon which we all work and live. I want to remind us that decolonization must be a material practice and not a metaphor, and that recognition affirms a commitment to supporting Indigenous rights, as well as expresses gratitude for all that these lands have provided for all of us. I want to encourage the decolonial practice in which I participate, and actually am co-organizing a conference that's participating in right now, of contributing to Indigenous organizations. The one that we have chosen is the Warrior Women Project. One of the things that I suspect will come up in this conversation is one of divestment, divesting from colonial organizations, from racist organizations, and reinvesting in people of color, in structurally marginalized groups is a really important tool that we have for combating oppression. And so even though we have to hold our institutions accountable, I also want to identify and name that practice as one that can help in this struggle that we are all in together. So with that, I'm going to talk about this book, which if Dean Keller and I have been friends for 18 years, this book has been hanging around for about 10 of them, I think. So she has been there for the entirety of that time. We had quite a moment when the book when it came out. It really was sort of the end of an era. So the story I want to tell today is actually not about the content of the book, but it is about the genesis of the book. I figure since this is a law review forum, that talking a little bit about how we got from point A to point B would be helpful, and also contextualizing the struggle. So what are these projects that we all work on? Why do they matter? And how do they fit into the conversations that we're having? So I received a set of questions that I'm sort of loosely going to work with, and we can definitely get into more detail in the Q&A. It looks like there are quite a few people here, so I'm guessing there will be a lot of questions. Let me start with this question of how I started with race and IP, which is a funny story because I was under the impression that this might be an area of law in which race did not matter. And I was very quickly disabused of that notion. Those were the days when I did not understand how the world worked. If I had known what I knew then, I may have made exactly the same choices, just, with a little more foresight. So Dean Keller and I were studying in law school. I thought I was going to be a civil rights lawyer. I had done some work with the ACLU. I worked with the Michigan Department of Civil Rights. And I came to this realization that actually it's pretty emotionally taxing to do race work. And I had some second thoughts about it. I had been on this moot court team that was doing was involved with a trademark moot court problem, the Saul Lefkowitz moot court team. And I thought to myself, well, this seems pretty interesting, and these brand stories are fascinating, so maybe this is a thing I can do. I went to school for my LLM, and I realized pretty quickly as I was studying international human rights law, and I was studying these sort of development questions that were coming up with the WTO, with TRIPS and so on, that actually race was extremely unavoidable in these spaces. And the rest is kind of history. I clerked for a couple of years. I went to graduate school. I was still under the illusion that I might not do race work. And, sometimes your calling is your calling, and your people bring you in. And that's the long and short of the story. And I think that's what happened here, that I had some mentors, I had some friends that made it clear to me that not like, and they made it clear to me sort of way, but our work together, our time together made it clear to me that this was really a place where I was interested in doing work and interested in having conversations with the other scholars that were working in this space. So that leads me to this second question of what pushed me to write the book. And one of the answers to that question is very unglamorous. It is keeping my job. That was the immediate concern of writing the book. In the world of the humanities and social sciences, we have book disciplines and we have article disciplines. I happen to be in a book discipline, so there wasn't really any way around writing a book. Why this book, I think, is a more interesting question, and one that has a little bit more agency on my part. Why this book, I think, is a question of both curiosity and of grounding. So on the one hand, I had been reading all this great work in graduate school. I had been getting to know the work of some of the scholars we're going to talk about today, Madhavi Sundar, KJ Green, Rosemary Coombe, and I had the opportunity to study with Professor Coombe when I was in Germany for a cultural studies and law workshop. And I was starstruck in those days. I was like, this is amazing. And I thought it was the coolest, most amazing thing ever. I still do. I do still love my job, and I still get starstruck. But there was something about that moment of being able to be in this space, talking to these scholars that were interested in race and IP. It's interesting that we've kind of gone the long haul. So in that 2-week workshop, there were interdisciplinary scholars that worked across law and the humanities and social sciences. And we really started to form this network of scholars. At the same time, I was working with Dean Keller, and we had been talking about this race and IP question for a long time. So, I think that a lot of what went into this book was a question of grounding for me. It was, well, what is happening in race and intellectual property, and how do I bring to bear these stories that I am learning about and speaking to in this highly theoretical space of Black studies, of ethnic studies, of cultural studies, all these diverse spaces that you may or may not have worked in as an undergraduate. And I wanted to bring them to bear on this question of IP, and ask the question of how IP came to be what it is, and how race fit into that big picture. So I knew that there were bits and pieces of that story, but I wanted something more comprehensive in terms of mapping. And I wasn't sure where that would lead. So this was a bit of an exploratory project. I have a very wise friend that told me they're a couple years ahead of me in terms of tenure. And they said to me, you'll know what the book is about after you finish writing it. And I was like, well, that seems absurd. And it's absolutely true that, writing a book is a collaborative process. And so I think we think about texts as these static items that just exist in the world, but really they're just, I think, momentary snapshots of the conversation that we're having in that moment. And so those conversations evolve, they change, they are revised in real time. I think remembering that is really helpful in understanding how conversations move forward. So that's what I'll say about the book, and it's why this book. What ended up happening as I was grounding myself was that I realized that I wanted to write a book that was a history, an overarching history of race and intellectual property. And then I went through a long, arduous process of figuring out what methods I wanted to use, how to find those methods, regretting not going to school to be a historian, and so on and so forth. Just all these very natural things that come up, it turns out, when you're writing a book. So the stories, I think, are worth telling because they help the students to understand that this is not a linear process. It's not a linear process for everybody. It's not for anybody. It's not a neat and tidy process. It is an evolution over time, and it is a collaboration. So what do I hope for the field to accomplish? First and foremost, the thing I always want is material justice. So right now we're talking about vaccines. We're talking about how to get vaccines to the developing world. That is an IP question. That is a question that folks like Madhavi Sundar are talking about. We can talk about ownership of music. We can talk about how Black artists have been exploited. The 1619 Project took this up. We can talk about racist trademarks and how they perpetuate problematic stereotypes. So for me, what I really want is for the ideas to be taken up in a way that helps us to move closer toward what we might imagine to be equity. And for me, critical race theory is a tool to get from point A to point B. The ideas in and of themselves have never really brought me much, independent of the material justice that they're connected to. So I think it's really important that we not forget that that ideas are a means to an end. And much like coalitions, they are a means to an end. I'll talk a little bit more about coalitions when I talk about race and IP stories. So that's the first thing I want to highlight, this material justice question. The second thing that I want to talk about is how critical race IP can address this. So as much as I enjoy the positive feedback about the book, though, I will say that being on camera has never been my jam. I love talking about the ideas. I love that people are taking them up. I also want to decenter myself in terms of that project of critical race IP, because there are a number of scholars that came before. There will be scholars that come after. Y'all are going to take up this project. I see critical race IP as part of a larger political project, and this book is just one piece of that puzzle. So how can we advance that conversation? How can we add to it? How can we move it in new directions that help you to think about, what you want to do with your careers, that help my colleagues and I think about how we can problem solve particular difficult areas, how we can get arguments through to judges, etc. Right? That's the political project. So insofar as this book can help us engage that political project, insofar as it can help people get excited about that political project and on a side of justice, I am for that. But I also think that this is a much bigger picture. I will point you to the piece that Dean Keller and I wrote called Critical Race IP that I think outlines a larger agenda for what we understand to be some of the intersections of critical race theory and IP. And I think that law review article both is backward looking in the sense that it puts together a literature review. It helps us to understand what came before the work of scholars like Keith Aoki, like Maggie Chon, and also the critical race theorists, the Derek Bells, the Devin Carbatos, the Kimberly Crenshaws of the world, without whom we literally would not be here. So I think in that respect, it's backward looking insofar as it helps us to put together a literature review of those areas and how they have evolved over time. It's also forward looking insofar as it identifies some of the themes that have animated race and intellectual property. And some of those themes include what the public domain is and what it should include and what justice looks like in the space of the public domain. It includes piracy, questions of piracy and how piracy gets racialized and how we might undo that language. So there is a big political project here that I want to center in terms of the past and the future, and I'm excited to hear what all of you will end up to hear and see what all of you will end up contributing to that. So the thing I want to end with is this broad question of what stories do I have to tell about race and IP? And I'm actually going to use this as an opportunity to talk about the forms of politics. I'm going to talk about politics as in a critical race theory sense, as a coalitional space of coming together to complete projects in the world. And then I'm going to end with just the thesis of the book, because I should at least pretend to mention the book in this whole spiel, but I'm sure we'll get into the ideas of the book. So what do I want to talk about with respect to race and IP? Really, I want to nod to all of the people that I had conversations with, that I was in coalition with, that came to the Race and IP conference to have these conversations, that did their own thinking, that contributed in some way to the working out of this project. To me, the story of critical race IP and this book is as much tied up in this conference that Dean Keller and myself co-organized with a number of other people and the communities around that, as it is about what I put on the paper. Working through projects is a process. And as Derek Bell talks about, it is also a process that involves interest convergence. In order to make things happen in the world, we have to engage with people. We have to produce leverage. We have to find those moments where the interests of scholars of color and white scholars intersect. It's always interesting teaching. So I teach in African and African diaspora studies. I teach in communication, and I know that this may seem outrageous, but I get some radical young people in those classes. And there is, cancel culture is real in the sense that students don't want to continue to face oppression, and that is very, very reasonable. The conversation that we have in my classes tends to focus on what it means to form a coalition with people, what it means to step back and say, well, I have to work with this person, even though I don't necessarily agree with all their politics, or maybe I don't even like them. But what does it mean to work together to get to a certain point It means being able to set our identities and our likes and our dislikes aside for the purposes of achieving a goal. I am running co-organizing a conference right now. I'm kind of running the behind the scenes of it, called Building the Fugitive Academy. And one of the comments that came up last week that I thought was really poignant and appropriate was that coalitions are a means to an end. They are not an end in themselves. When we forget that the scholarship is not an end in itself, I think we lose something of the process. So the story that I want to leave you with is of all of the people that have contributed to this, to Critical Race IP as this living, breathing project that's going to have these conferences with evolving spaces. And also scholarship as just a snapshot of the moment, as opposed to what I think often gets called this great man theory of history and philosophy. I don't quite buy that as much as I buy the idea that feminists of color tend to talk about collaboration producing scholarship. So let me just end by talking about the thesis of the book. The book is about the connections between race and citizenship in 3 areas of intellectual property: copyright, patent, and trademark law. And really what I'm interested in doing is exploring how citizenship is mediated through intellectual property law, and how it is also connected to ideas of race. The method that I use to explore that is this idea of racial scripts that comes from the work of Natalia Molina. Unless you think no one listens to ethnic studies and American studies scholars, she won a MacArthur Award this year, which I think is pretty wonderful. This idea of racial scripts is just the notion that we have stereotypes that co-occur, or they occur time and time again as fragments in our cultural discourses. And so we can apply them across racial groups. We can apply them in ways that perpetuate racism. So the thing that I do is I look at 3 themes that emerge over time from the 1790s to the end of the Obama administration in each of those areas. I identify these 3 themes as relating to questions of race. In the area of copyright, identify this notion of true imagination. So who does and doesn't have true imagination becomes a way of marking humanity and also creatorship. The idea of human progress in the context of patent law, I think, accomplishes a similar thing. And then in the context of trademark law, the idea that identifies that of the white male consumer gaze. So I ask the question of who is doing the looking, who is doing the perceiving in these branded spaces that we have, and why does our visual culture operate in the way that it does. The last chapter of the book basically looks at resistance to these 3 areas. The last chapter takes a look at this idea of IP fugitivity. So it draws on multiple narratives in intellectual property law about fugitivity, and also the work of Black Studies scholar Fred Moten, which I think is extraordinary and important as we think about how to build these progressive spaces in the academy. So with that, I am going to pass the microphone. I don't know who's next, but I will let y'all decide.
Well, what we'd be happy to do is I actually have a follow-up question for you, Professor Vats, but also for anyone. And I would like, as we move forward and sort of open up the Q&A to the entire audience, for our panelists to feel free to just unmute yourselves and contribute as you see fit. And Professor Varyani will be graciously taking over in just a moment. But going off of some of the things you just said made me think about actually our class, Critical Race Theory in the Law, taught by Professor Varyani. And something that she talks about a lot is the power of narrative, not only to perpetuate these sort of racial scripts, but also to sort of unpack and understand them. So for people in the room who maybe haven't read the book or aren't super familiar with critical race theory and certainly, critical race IP, I was wondering if you or if anyone would be willing to share a little bit more about some of the specific narratives you speak to in the book that sort of connect those concepts. I was really, for me reading the book, it was really helpful to sort of understand the material through these stories of Phyllis Wheatley, of Prince, of the Blurred Lines, lawsuit. So I was wondering if you might sort of paint the picture through one of these narratives for us.
Sure, absolutely. Let me take up the example. I think these are familiar cases to folks who study IP and certainly musically familiar to folks. Let me take up sampling as the example because I think it's an accessible one. And the argument that I make about sampling and the way that copyright law orients to sampling is that even when musicians of color, even when they score these victories in these sampling cases, that it is against a backdrop of the criminalization of Blackness and the exceptionalization of Black creativity. And I would say Black and brown creativity, even though a lot of these cases deal with Black musicians. In one of the first sampling cases, and the first one that suggested criminal penalty, Grand Upright Music versus Warner Brothers, Biz Markie gets sued for sampling the work of Gilbert O'Sullivan. And I like this case because it is so, to me, so stark that the same people do not listen to Gilbert O'Sullivan and Biz Markie. It is also very clear to me that Biz Markie did Gilbert O'Sullivan a solid because now every law student who studies IP has to listen to Gilbert O'Sullivan's music to understand what's happening in this case, right? So what happens in the outcome of the case is that the judge essentially, the judge starts with the seventh commandment, I think it's number 7, thou shalt not steal, and literally invokes the seventh commandment, which not only is pretty heavy-handed way of going about this question of copyright infringement, but it's also projecting all of the criminalization of Blackness that's happening out in the world, the fear of crime rhetoric that's coming out of the Reagan era that is bleeding into the Clinton era. It's projecting all of that into this copyright space. So for me, that's the starting point of what then people like to read as these cases, Campbell versus Acuff Rose, for instance, that are victories for Black artists, except they're only victories if you think that parody and fair use are expansive doctrines. And they're only victories if you think that Black creativity and Black brilliance are exceptional. So what the judge does in that case, and this is the thing that I think happens historically over and over again in the context of Phyllis Wheatley, as you mentioned, in the context of a case called Supreme Records versus Decca Records that involves race records, there is this marginalization of Black creativity and also a complete erasure of how we got to where we got. In order to say that somebody is stealing something, you sort of have to come to terms with how the property got distributed in the first place. So, you know, if the property was already stolen to begin with, then we're having a different conversation, right? That judge is really saying, we're not letting you steal back the thing that we stole from you. And I think that is what gets lost in some of these cases, that there is a racial undercurrent here and a racial superstructure to law. And this is what critical race theorists are interested in pointing us to, that there is an overarching racial logic to law and intellectual property law and copyright in this particular case that is crafted around an imaginary of who is and isn't capable of producing new and meaningful ideas. We see this all the time in the way people talk about rigor, in the way they talk about excellence, in the way that they gatekeep. And so now we have become very conscious, I think, of saying, well, is this gatekeeping, or is it actually genuinely helping the scholar to be better? Or, am I recognizing the creativity of the artist here or not? But I think that parody example where this song by the Two Live Crew gets marked as fair use because it is a parody of the song, the song that is in the movie Pretty Woman, that's not actually as big of a victory as people want it to be. That it is a framing that is actually really kind of restrictive, and one that represents what Alan Freeman, who is a critical legal theorist, would say is the perpetrator perspective. And this, of course, underlines all of critical race theory, this idea that civil rights law really wasn't about creating equity in the United States, but it proceeded from a very narrow understanding of what racism is. Racism has to be conscious, it has to be identifiable. It generally is carried out by white people in the South, right? So this restrictive understanding of what race is and how race operates keeps us from getting to the point of equity.
Can I add something to that? Because I think the other thing that that Campbell v. Acuff-Rose does is it buries this kind of procedural victory for the other side, right? So it's Campbell v. Acuff-Rose that is the first time the Supreme Court articulates fair use as an affirmative defense, right? Which now that means it's on the defendant to prove, right, that their use falls within the strictures of fair use. And so in the kind of victory for Two Live Crew is buried this procedural bomb, right, that's going to shift the capacity of defendants to defend, right? And so I think that's a really important thing to keep at the top of your mind, because I think it's also a thing that happens in civil rights litigation, right? This shifting of the burden, if you will, to demonstrate your worthiness, right? I mean, they're very kind of parallel things that are happening, and they happen in a way that is almost invisible, right? That unless you're looking for it, you can't find it. And I just will say that I think that's one of the key contributions of the book, right? Is I think a lot of people think, what does race have to do with IP? And one of the key contributions of the book is that it makes really clear that IP is like everything else, right? It's a part of our culture. And so the superstructure that Professor Vats points to it's everywhere, right? In my response to the book, I'm going to talk about how Charles W. Mills names white supremacy as the system that has shaped the modern world, right? And what the reason that it's so powerful in doing that is because it remains silent, right? It's because we don't speak about it and we don't identify it. And so I think what's really one of the major contributions of the book is that it does identify the form of white supremacy. It maps white supremacy as it's showing up in IP law.
I would add to that, I agree 100%. And I would add that I think even if you go back to Grand Upright Music, that you can say that the judge there had the opportunity to navigate that space creatively. Like the judge actually had a lot of judicial space to decide how to manage sampling and how to relate to Bismarcky. And the path that the judge took was like maximum racist, right? It was, if there was meter, he was like way over on this side. And I like to imagine all the different ways that fair use could have been read in that case. and also that the judge could have read Black brilliance and Black creativity differently. Because, you know, Ms. Markey is actually doing a really creative and brilliant thing that is far above what we consider to be necessary for creating something that is copyrightable under the law.
If I can jump in, I'm going to start by saying that totally resonates with me, and I love sort of the metaphor when you talk about sort of the shifting of burdens and the changing this to an affirmative defense. That is so resonant with me because of the way I understand that the world is navigated by so many people of color, sort of the way that burdens have shifted to prove that you are there and that you are worth it. So even though I love sort of the parallel in the sort of legal, the legal procedure and sort of metaphorically how it works in the world. So I love all of that. And I haven't known you for 18 years, but I feel after reading your book that I've been having a conversation with you. I just haven't been speaking to you yet. So before Brie, I don't know if you want to talk about procedure for hand raising, and then I will moderate. Go ahead.
Perfect. Thank you so much. I know certainly members of the journal have had questions on their mind, but I'm sure everyone in the audience does. So if everyone, and I know Professor Varyani has tons and tons of questions as well. So if everyone just wants to utilize the hand raising function very much in a class format, so that Professor Varyani can see who has questions to ask. And if I just want to remind everyone that because this is being recorded, if you do ask a question, you will be featured in the recording. So if you'd prefer not to, feel free to privately chat your question to me or to Professor Varyani directly, and we'll make sure that it gets asked for you. So feel free to go ahead and raise hands, but I know Professor Varyani, if you have a lead-off question, I'm more than happy to defer back to you.
So I really appreciate Brie's question from that builds on some of the narrative structures that we've talked about in critical race theory. And I want to talk about sort of the white male consumer gaze that you mentioned briefly and that you talk about in your book. And I want to sort of marry that with the concept of interest convergence, the Derek Bell sort of concept, because it requires, again, when we were thinking about shifting burden and who bears the burden and of what, those concepts really bring that together for me too. When we think about interest convergence, it really requires people to understand the white male gaze of consumerism and then craft an interest that converges with that. And that strikes me as a lot of work before you even start. And so I wondered if you had any have any comments on that. I really also, I hope that sometime before the end of this, I know it's certainly, you couldn't address it in your book, but I know we have been thinking in particular about anti-Asian hate crimes and violence. And I think sort of the messaging we get through IP sort of certified marks and the way that we consume things has an impact on that. So I'd love at some point when you are thinking or talking about these issues to sort of try to weave in how the principles that we are thinking about, and maybe some of us are struggling with in a particular way very recently, may relate to the concepts in your book. Amaka, I'm going to call on you for the first actual question.
Hi, thank you so much for being for this symposium review. It's really a privilege because there's so many people that inspire me that are on the panel. Professor Osei-Tutu, Professor Vats, like your work inspire me so much. So it's really a pleasure to be here. My question is, so the first time I came across race IP was when I'd already handed in my PhD thesis. And I just thought to myself, like, dang, like I really needed this, right? So now that the PhD is done and my book is out, so I'm beginning the project I'm working on now is on race and IP, and of course, from a global perspective, but at the same time, I want it grounded within what is happening within Africa. So my question for you is this: whenever I discuss race and IP, most of the comments I get is it only applies in the US, right? From your experience, how does that play out within, how does that play out outside the US, for example, in Africa, where there are only few states within the continent that have really developed advanced IP regime. So in that instance, I know race plays out in a way even within the continent, but I'm still trying to grapple in what aspects, I'm reading through your book, and hopefully by the time I get to the last page, it will answer my question. I was just wondering if you have experience in terms of race and IP, how that plays out outside developed countries like the US, in the global South in generally. Thank you.
I'm going to use my moderator voice to interject one more time before you answer that, Professor Vats. Please answer this. And then once you do, I'd like to hear from our other panelists too for short responses to your talk. So go ahead. Apologies for that.
No worries, no worries. Let me just do like a very abbreviated response here, and then pass the microphone. I think there's some good overlap here. So with respect to interest convergence and consumer culture, one of the things that happens when I teach critical race theory, students are like, but how do we live this, right? Like, how do we do this in the courtroom? How do we do this while we're lawyering? What I think is important to thinking about that is the question of leverage at a micro level, right? So we're not really thinking about how we can say have the same politics as white men. We're thinking about as activists, I think how we can break up the steps of getting from point B. So point A to point B. So one example where this comes up for me is doing diversity and inclusion work, right? In order to do diversity and inclusion work in the academy, or whatever professional space you're in, you have to have buy-in, right? So there's no way around buy-in. I think we're doing the same thing in this sort of brand consumer culture, and I think Dean Keller can speak to this with her comments. I think that they will get at this question as well. For me, if we start to think in that space, what are we thinking? Well, we're thinking about how we can produce the leverage to make it more costly for Dan Snyder to keep that trademark than to retire it, right? And so interest convergence looks like protests. It looks like rallying the troops, right? And that has to be a multiracial coalition of people that's like, okay, we're done with this. We're not doing this racism in this way anymore, right? Like, let's find a new way to do it at the very least, which is what we end up seeing. It means writing the newspaper articles, moving public opinion, and so on and so forth. And so that's how I think about interest convergence at a practical level. The second question about international context, I would say thank you for this question. I think absolutely there's a space for critical race theory at an international level. Francisco Valdez and Angela Harris write about this in the collection that they write about futures of critical race theory. But I think Professor Osei-Tutu will be able to speak to this question. So I'm going to pass to her and then let the two other folks here say some brilliant words.
Thank you, Anjali, and thank you, Amaka, for your question. So actually, that's what I was planning to speak about or that's what I'm writing about in my response to Professor Vats, is this international perspective. So I actually think it's really an interesting thing because critical race IP critical race theory tends to be very much US focused. I would say that in international space, you'll find that kind of critical approach in a lot of different ways. It shows up in TWAIL, Third World Approaches to International Law, which is very much a critical perspective that sort of even things that like Maggie Chan's IP from Below, Kitheoki, Chidia Guamanam, it shows up in a lot of different areas. And I think it's a really important conversation. Actually wrote a piece some years ago talking about Derek Bell's interest convergence, but my spin on it was that we actually need value divergence in the international space before our interests can even begin to converge, because part of what happens in the international space is we're looking at very much a Western approach to IP. And I think Professor Vats, you talked about this a little bit in your book when you talked about in the Indian context, people speaking about cultural IP, but there's really no cultural IP. They think there is, but then there isn't. And part of our pushback is to say, well, there isn't now, or at least it's not internationally recognized, but why is there no cultural IP? So those of us taking the sort of third world approach would say, in fact, there is cultural IP. It's just not being acknowledged because of who's structuring the system. So I think it shows up there. I think it shows up in the traditional knowledge discussions that have been going on forever at WIPO. And it's really interesting to me if you think about, and I'll try to be brief here, I'll cut it short, I don't want to take too much time, but I have to say this, it's so interesting to me that when we try to protect traditional knowledge, it takes so much effort, so much energy, it's dismissed as not being creative, it's dismissed as not being innovative. But if you want to protect European cultural property through geographical indications, then it's okay. It's in the WTO agreement. And, you know, people would push back and say, oh, the geographical indications are not about European culture. The Europeans have said geographical indications are about European culture. So what are we really talking about? So I think there's that. And the last thing I'll say is that I think it shows up in the human rights conversations. When you talk about human rights approaches to intellectual property, it's really about acknowledging that we maybe want to have a different structure that acknowledges human dignity, which is the core of your book, Professor Vats. And I would suggest, and that's, I think you end with your last sentence is about human dignity. And I thought this is just about human rights approaches to IP. So it's critical race theory, I think is extremely relevant. It ties in so many different ways. And so I think, Amaka, it's really important work. And we just, like to some extent, you know, I said at the beginning, I don't necessarily describe myself about writing about critical race IP, but when I was reading the book, I said, yes, 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 it's all over the place. So I think there's definitely space for that.
Professor Osei-Tutu, I hope you take all of the space because I love your perspective. Don't ever cut yourself short. Yes. Professor Keller, Dean Keller, I'm sorry. Do you want to give a response? I know we've heard from you a little bit, but I suspect we have a lot more. There's a lot more.
Yes. So I'm going to respond to this line of discussion in particular. So first, in terms of IP in Africa, the first name that comes to mind for me is Boatsma Boateng, right? Whose book, That Copyright Thing Doesn't Work Here, 2011 book. If you're not familiar with it, go get it. When I'm thinking about IP on the continent, Boatsma's work is the first thing that comes to mind. So I'll say that. But secondly, I really sort of the challenge of Professor Vats' book for me was really this sort of yoking together of American stories and international stories, right? Like, what does Phyllis Wheatley have to do with yoga piracy, right? How do we understand these things within the same framework? And that's actually what led me to Mills. It's that kind of, how do we yoke together these conceptions has been on my mind as long as I've been thinking about IP and structures of power, and structures of power that are racialized or, you know, come from a place of ethnic superiority and the like, right? And so the work that Mills' book does is really to get us to see how the colonialist logics that render, you know, that write Indians out of the social contract are really not that different from the eugenicist logics that wrote enslaved persons out of the social contract, right? And so I think that framework is the thing that has helped me to understand the interrelatedness of the story about yoga piracy and the story about Phyllis Wheatley. And so I suggest that model to you all. It's, I think that gets us back to sort of this coalitional question, right? Because thinking about a counter politics, an anti-racist politics, and an anti-racist politics of IP in particular is does demand some consideration of coalition as a means to an end, right? And I think Professor Vats is exactly right to be pointing that out. Along those lines, there is, so if you're not familiar with Rodrigo's Chronicles, go find it. It's wonderful. It's a series of effectively short stories, one of which is about coalitional politics and the challenges of coalitional politics in anti-racism work. And so I think that whenever I'm thinking about coalitional politics, I'm thinking about the work done in Rodrigo's Chronicles to lay out the landmines, if you will, of coalitional politics. And then I just will kind of round that out by saying, I think and to bring it back to the book, I think one of the kind of nascent themes in the book that I think is an important contribution to the conversation is how IP is central not only to kind of the materialist justice issues that Professor Vats pointed at earlier, but also what the critical race theorists refer to as idealist justice, right? And so that there's sort of this dichotomy in the critical race theory world between, are you working towards material justice, right? Are you trying to make people's lived lives better? Or are you working against stereotype, right? And I actually think the work of racial justice is both and. You have to be doing both of those things at once. And what IP does is it kind of sits at the crux of those, right? Because we have, the book is demonstrative of how kind of racial or racialized trademarks impact the way we think about stereotypes, right? That's really kind of idealist stuff, right? But then on the materialist side, how the exploitation of Black creators rob them of wealth, right? And so IP is this really interesting fulcrum that sits at, the corners of both of those things, and I think provides us an opportunity to think about how we can move the needle on both sides as to both, changing the thinking around stereotypes and the like, and also having an impact on people's lived lives, right? A materialist impact on people's lived lives. And I think that's what makes this conversation about race and IP so important, right? Is that IP really is an opportunity to walk down both of those roads at once.
I love this way of connecting all of the different case studies and areas. I think Charles Mills's work is one great way to do that. I also think that the work of racial capitalism does some of that work. So when we start to think about what shared oppression looks like, Angela Harris has this very short blog piece that I think is great about law and political economy and race. And one of the things she says is, we have to stop thinking about racial capitalism as purely an American thing. Racial capitalism starts with imperialism. Right? There are common histories of imperialism. And so to me, critical race theory is always already international, because these struggles have always been international. I was having a conversation with a couple colleagues, and I taught some material on political Blackness in the UK. One of the things that fascinates me about political Blackness as a concept in British Black power is that it was a multiracial coalition, even though it was called political Blackness, because folks were united around both class and coloniality. And so I think one of the things that the United States has effectively done is try to separate our struggle of race from the colonial struggle of race. And those, to me, are not separable, in the same way that, as Dean Keller says, liberalism is not separable from any of these conversations. These are all global trajectories that are interrelated.
Yeah. Absolutely. And particularly when we were thinking and talking about the exploitation of Black excellence, the other side of that for me is how there is the binary of the whiteness that gets exploded, that gets very popularized, they can be by the proximity to Black culture, right? So not only are they dispossessing Black creators of their value and worth, but there are sort of people who have not had a Black lived experience, who just by the proximity to that can get a lot of property value. So I have a couple of questions that were given to me in chat. Raji, hello, I see your hand, but I'm going to ask a couple of the questions that I've received. The first one comes from Emily, who asks, while cancel culture has helped to remove some racist and inappropriate trademarks from commerce, where Section 2A of the Lanham Act is unable to, could this have backfired by leaving mainly white personas in commerce? So the Quaker Oats, Captain Crunch, Colonel Sanders, or is this part of a bigger picture in which more people of color will be featured in trademarks or brand representatives, but in a respectful way? And then Emily asks, is that even possible? So I will leave that to any of the panelists. That's a big one.
I'm not going to answer this question directly. I'll leave that to Professor Vats, but I just want to point you guys to Roxane Gay has there's a very recent interview with Roxane Gay in which she says there is no such thing as cancel culture. It's consequence culture. And Roxane Gay is, of course, always right. So it's in Mother Jones.
It's true.
I wish you would answer that question, because that is a great question and a hard question. Does it backfire? You know, the argument that I make in the book related to TAM is that the problem of TAM, Mattel versus TAM, is that it defaults us, this expansive view of the First Amendment as not allowing for the cancellation of disparaging trademarks, gets us back to a world of racial liberalism and the market as the default. I never want to default to the market, because we don't seem interested as a nation in producing ethical capitalism. So, you know, the market, there's also all these economic, you know, projections, fantasies projected onto the market that I don't think are true, right? Rational actors are not real. There's racism, it's not efficient, and yet it continues, right? Like there's just all of these economic problems with letting the market regulate racism in any sort of way. So what happens when we only have white trademarks? You know, I think that there are so many sources of white supremacy at this moment that if our biggest problem was that we only had white trademarks left, that I would take that world. That would actually be probably better than the alternatives that we have. I don't know, it's an interesting question, because I think these hierarchies are so entrenched that we're really just chipping off such like this gigantic rock, you know. There's a reason that people use the metaphor of brick by brick, because there are many bricks to be removed from that wall. So I think that there might be a shift, but this is partly why I want to shift us to the conversation about structural power. One of the conversations that Dean Keller and I had long ago that was, I think, really deeply formative to critical race IP work was that aha moment we had where we were like, we cannot look at the outcomes of cases, because if we focus on the outcomes and who wins and who loses, we're missing things, right? Like this can't be the only metric for understanding what's happening racially here. And so I think that shift in our thinking from the individual outcome of cases to the structural was really productive in helping to understand what the racial logics of IP are. And I would say the same thing about this trademark space. So let's imagine a world in which we're only left with Colonel Sanders as our, you know, and the Fighting Irish and so on and so forth. Does that move the structural power of trademark law? I would argue not really. That part of the heft of brand culture comes from racial capitalism, and it comes from how the market works around the production of sometimes commodities that aren't that don't have racial icons. I'm thinking of the Urban Outfitters case here with Urban Outfitters selling the Navajo print underwear, and you know, there's a bazillion Urban Outfitters cases we could talk about that they really like to push the envelope. But I don't think it would move structural power, and I think it would be, there would still be opportunities for people to express their racism in other ways that were less literal, perhaps.
If I could just jump in on that one. I think it's a really interesting question, Emily, and it's something that I thought about a little bit, but I think it's not just about having only white trademarks. I think it's about the way that people are portrayed. So when I was a young lawyer, there was a white lawyer who said he couldn't give me any work because I reminded him of Aunt Jemima. So it's not just the fact that you have a Black woman who's on who's being used as for branding purposes, it's the way she's being used. So the trademark is communicating some kind of message. And what is the message that is being communicated about Aunt Jemima, right? So I think that's part of the problem. And so if companies want to be diverse and inclusive, then they need to do it in a way that's respectful. So I think that, I agree that it doesn't change the structure, but I think that there is some change, just as in terms of television portrayals of different people of color. You might say it doesn't change the structure of the power, in terms of power, but it does change to some extent, maybe our perception. And so I think it's relevant there. And one last thing I want to say about cancel culture is that it strikes me that cancel culture is being used when we talk about cultural appropriation, not only against the white guy who's pretending to be an Indian, but we're seeing a lot of it used against people of color as well. So I think it's become a very interesting tool, and it's really, there's still that power structure that lies behind it. So those are my thoughts.
I wish we had Professor Cottill here to weigh in on the trademark question. So if you don't know Sonia Cottill's work, she was one of the first people to write about trademarks and race, and I think that she's done some brilliant interviews recently at the intersections of those two topics as well.
Well, we cannot wait to read her response in this issue. Raji, I'll take your question, and then I have a bunch of chat questions, so I'm happy to take those, but I suspect that you might tire of my voice, so feel free also to raise your hand. Let's hear it, Raji. It's nice to see you, or to be in the Zoom space with you. Go ahead. I can see you're unmuted, but I don't know. I can't hear anything from you. While you figure that out, I am going to ask one of my chat questions, and I'm going to choose one. I think that this is for Professor Vats. This person is asking about how your book combined Afrofuturism and Afro-pessimism, because they're normally seen as opposite theories. So if you could talk a little bit about your thoughts on that, that would be great while we wait for Raji's audio.
Yeah, so Afro-pessimism is, I think, a particular orientation to thinking about the way that Black people are able to move in the world. For me, when I think of Afro-pessimism, I think that it is about relating to a particular narrative of slavery and what the long-term repercussions of that are, and also thinking about what it means to be Black and human, or how the world understands those two categories to coexist. So, to the extent that the book draws on Afrofuturist themes, I tend to not be full on in the Afrofuture, or that Afro-pessimist, excuse me. I'm mixing up the words here. So I tend to not be in the Afro-pessimist camp as much as the Afrofuturist camp. I do think, though, that Afro-pessimism is really formative in Black studies and thinking about questions of race in the United States and beyond. And so I think it does a disservice to Black studies to not engage with strands of Black studies, and especially those contemporary strands of Afro-pessimism that, you know, include the work of Sadia Hartman or Christina Sharp, and so on. So I think that's one thing that I'll say. And then the other thing is that, you know, I think Derek Bell's work is a really interesting example here of how we might be able to combine both the Afro pessimist, right? Though I feel like Dean Keller will say some words about whether Derek Bell is an Afro pessimist or not. But Derek Bell certainly both believes in racial realism and Afrofuturism at the same time. The Space Traders is an Afrofuturist story. Afrolantia is an Afrofuturist story. But at the same time, I think he occupies a particular space with respect to this notion of social death and what social death means. He is not dealing with it explicitly, that I'm, at least in the work that I have read of his. There may be in other places, but, you know, I think it can be a both and. So I also want to invoke the work of Fred Moten there, because, you know, I've perhaps committed a scholarly faux pas in both citing Orlando Patterson and, you know, this idea, this origin of Afro-pessimism, and then talking about Fred Moten, who I think lots of people imagine to be an Afro-optimist, right? That's why he's talking about fugitive spaces. He's talking about creating fugitive spaces as these places of joy and the opposite of social death, right? Like that is precisely what the fugitive space is about. So, you know, I think there are these inherent contradictions in writing about race. I think that there are also inherent contradictions in living race, and parsing that is part of the work that we do.
Yeah, I think it's really difficult to sometimes hold two contrary things in your person, and yet we're asked to do it over and over. I think that's a really insightful response. Raji has texted me that, or has messaged me that he thinks he's worked out his audio issue. Let's hear it.
Hello, can you hear me?
Yes.
Yes.
All right, sorry about that. So my question was that in critical race theory, there's the idea of reclaiming hateful names. I was wondering how that would apply to reclaiming hateful images, because, for example, I guess recently Harvard was profiting off of images of slaves. So I was wondering how you would be able to, using IP law, kind of reclaim those images.
Dean Keller, I kind of want to pass that one to you, because I know that you've been writing in that trademark space a bit, and when in talking about BLM and personhood and so on. I don't mean to put you on the spot, but if you have some thoughts.
Yeah, no, that's fine. I don't mind being put on the spot. And I don't know what I can add to the conversation about Afro-pessimism and Afrofuturism, because I was going to say these things live together in the person of Derek Bell. And so sometimes when you've been having conversations with the same person for 18 years, you have a mind meld. And that was definitely one of those moments. On the question of reclaiming negative verbiage. So I think the thing that followed in the wake of TAM was a number of applications, trademark applications for the N-word, right? And it wasn't surprising to anyone. Everyone knew that was coming, right? N-word applications had been rejected by the office on the basis of 2A forever. And then 2A went down in TAM, right? And then there was this sort of groundswell, more than you would have liked or been comfortable with, of applications for N-word trademarks. And some of those were articulated by the applicants as precisely this, right? Attempts to reclaim the term, attempts to block others from trademarking N-word marks, all of those kinds of things. And I guess what I'll say about this is the most illuminating discourse around why that word is so harmful and perhaps beyond the pale of reclamation that I have heard is an interview with Ta-Nehisi Coates, in which he talks about why white people should never, ever say that word, not in singing lyrics, not ever, right? And one of the things he says, I'll share kind of a couple of themes from that. The first is that context is everything, right? And so he talks about how, if his wife calls him honey, that's one thing. But if he's walking down the street with his wife and another woman calls him honey, that's something else altogether, right? And so because there's always kind of this argument about the N word that, well, Black people use it, so why can't we? And his answer to that is because context matters, right? And then the other piece of that is, and this is the piece that I think really has always stayed with me, and it's the reason that word, it doesn't have a corollary for white people, right? And that is, he says, look, there are human beings for whom that was the last word they ever heard, right, as they were being lynched. And so why would you want this thing? Why would you want to invoke that pain, that history, that context? And I think that has always stayed with me. And so in my thinking about this, there are things that are beyond reclamation, right? There's imagery that's beyond reclamation. There are phrases that are beyond reclamation because they still and always invoke pain and trauma, right? And I think part of what Professor Osei-Tutu was getting at in the reference to Aunt Jemima is this, right? Aunt Jemima is always invocative of slavery, right? And of the position of Black women in particular who were enslaved. And so that it is very difficult to disambiguate that imagery from that history. And so the way that Aunt Jemima was sort of reimagined didn't matter, right? So there's a new picture of Aunt Jemima. That doesn't make her any less Aunt Jemima, right? And it doesn't invoke the histories of slavery and the traumas of slavery any less. And so I think there's a limit to what can be reclaimed, and that limit has to be articulated by the populations that are impacted by the symbol or word in question. And so I think that brings us all the way back around to, the Washington football team, right? There is, someone asked before, what would a marketplace with images of only white people look like? Well, part of what it would look like is not having Native Americans represented in this, ahistorical way, in this way as if they are gone, right? There are no more Native Americans. They are a thing of the past. And so I think when we think about reclamation, we have to also recognize the histories of this terminology and these images. And you can't really reclaim swastikas, right? They are what they are, and they are tied to a history of genocide and trauma. And so there is a limit to what can be reclaimed, I think.
Yeah, I would add to that. I would just add to that the thing about some of these images, when we talk about images and reclamation, they're reclaimed out of necessity, right? And so I think that also structurally speaks to what Dean Keller was saying, right? That there is a limit because it's not that the people wanted those things, right? It's like you have put these constraints on us and now we have to work within them, right? Would Marshawn Lynch have chosen beast mode, all other things being equal? I don't know. I'm trying to remember the name, Betty Sayre. Would Betty Sayre have chosen to make art about Aunt Jemima, right? So Betty Sayre is an interesting example when we talk about reclamation, because she's doing this radical Aunt Jemima art, right? It's like Aunt Jemima with a rifle. But, that still is replicating that mammy image, or the person that has put together the Museum of Racist Memorabilia. I mean, those are still mammy images, or sugar baby, I think is what the Domino Sugar, the big installation piece is called, right? All of these are reclamations of a sort, but they're reclamations of, I think, the embodied presence of Black people and Black women in particular in the context of Aunt Jemima. They are not necessarily, you know, reclamations in the way that we might think about how that case or how the example goes in with Dykes on Bikes, right? Like that is the sort of, I think, epitome of what can go right with reclamation. And very few cases, I think, especially visually, go that way.
I just wanted to say, just to add that the problem is, I think the question was also directed at trademark law. And the problem is trademark law, the way it's structured right now, can't help us because basically you can register marks defensively, as Dean Keller was explaining at the beginning, right? People register a whole bunch of marks with the idea that we're trying to block their use, but trademark law is structured such that if you have a mark and you don't use it in commerce, you have this non-use provision, then the mark becomes abandoned. So you either use this offensive mark in the marketplace or it's lost and somebody else can use it. So I heard a very interesting presentation where somebody was invoking the possibility of a morality clause. And under the international instruments, we have this sort of public order and morality. So it's not just in US law, but the sort of public order and morality clause, which has not been well defined or well explored as whether that should be a standard for limiting the use of some of these images or some of these names. And you might ask, can you still do that post-TAM? And I think the argument is that, you know, TAM wasn't specifically addressing that. So I would suggest that part of what we need to think about is whether we want to push IP law from staying within this sort of dominant commercial structure that we currently have right now that purports to be neutral but isn't really neutral, and then say we don't want to deal with morality and we need to leave that to the side, because that's where you could capture things like we don't want slave images being used for profit purposes. And so I don't think we have a good answer to that right now under the law, but I think part of the work that needs to be done is to push back on that.
I want to pull on a thread of something Professor Osei-Tutu just said, because I think it's really important. If you're thinking about anti-racist IP, you can't just presume that the law gives you the tools you need, right? You very often have to go outside of the existing legal structure and find some analogous tool, right, that you can deploy, because the law is not necessarily going to give you the tools that you need, right? And so we have to be creative. And this is why doing this work across disciplines is so important, right? Because the ethnic studies folks have some tools that we can adopt, right, as legal actors, and the cultural studies folks, they have some tools. And I just think it's really important to recognize that we're not going to find all the answers in the law. We're just not as it's currently constructed. So that's an important thread that I wanted to pull out of what Professor Osei-Tutu just said. And then the second thing that I'll tug at is this notion of IP law being just about the market, right? And Professor Vats motioned towards this earlier and said, you know, something along the lines of the liberal market, and I actually would call it the libertarian market, right? The hands-off, like let the market do what it does, and all of this will come out in the wash. And you know, the dominant discourse in IP law for a very long time has been law and economics, and that discourse does not serve racial justice, period. For many of the reasons that Professor Vats got at, but that I think is also underscored by what Professor Osei-Tutu just said. It does, because the biggest reason, though, is law and economics does not care about justice, right? It only cares about efficiency. And so that tool cannot get us to a more racially just IP system. And so if we accept that as the framework, then we're not going to get to the place that we're hoping to get to, right? You cannot get to anti-racist IP regimes from a law and economics framework. And I think that's another kind of nascent theme in the book, right? The book kind of presumes that law and economics isn't going to get us there, right? And reaches for tools outside of that framework. I think that's a really important methodological contribution.
Yeah, Professor Vats, you wanted to say something, go ahead.
Oh, I was just going to say, maybe we can take a couple of questions, 2 questions at a time, because I want folks to be able to ask their questions as well. Go ahead, please.
Yeah, no, I know Anna, it's lovely to see you. You have a question, and I also have some questions. I'm gonna read a question and then let Anna ask her question, and that will, I hope serve getting as many voices as possible. I have a question from someone named Daniel Oliveira, who's an international relations doctorate student in Brazil, which I think is worth noting. And he says that that many authors criticize IP and affirm that it's not possible to decolonize intellectual property since its nature is excluding, hierarchical, and unequal. In this sense, critical race IP, although it criticizes its IP nature and racial perspective, claims equal IP rights for Black and Indigenous people. And that may have some limitations in addressing the discussion about how people want to keep their rights over their cultural knowledge, but not have rights through their private property. Okay, so his question is, how do we move forward and propose ways of protecting Indigenous people's rights? And how can we do that internationally, which I think is similar to a question, the very first question we had. So I want to let that one simmer because it's a big one from someone who is in a different discipline, which sort of pairs nicely with what Dean Keller was saying about needing other disciplines. And I also want to hear from Anna. Go ahead.
Hi, Professor. So I guess I'll just give the disclaimer that I don't really know a ton about IP law, so this is just kind of like a general like observation that or something that kind of like stuck to my like history major brain was kind of maybe I was wondering if you could speak on the parallels of like race and IP and like blackface that happened, that, you know, of course happened a lot in like the entertainment and how that might relate to one another.
Yeah, great questions. I think that Daniel and I have sort of virtually met on Twitter, perhaps. The world is a weird place these days. So these are great questions. This first one about Indigenous rights is obviously, I don't have to tell you this, a gigantic one. But the first, let me say 2 things and then I'll pass on this question because I think other folks will have thoughts on this as well. But the first thing that I want to say is that the way that I frame this in the context of yoga is that we have to think about both decolonization and de-Westernization is the way that Walter Mignolo thinks about this. So decolonization is a different process in the sense that it is trying to articulate some of those values that Professor Osei-Tutu was identifying, right? This notion that we can have a multiplicity of methods for protecting IP, right? But not everyone wants to protect it. Not every culture comes from a rights-based understanding of the way that knowledge should be circulated and shared. So what de-Westernization, I think, gets at is the need for a multiplicity of models of thinking about protecting intellectual property, or even getting new words to think about this. There are multiple ways to undo and resist intellectual property, and one of those ways is to say, let's start at a different place. Let's not presume that we need to start with these laws. Let's presume that we want to start with the values of other groups and use those as a way of reconstructing some of these ideas. So that's the first thing I'll say. The second thing that I'll say is that I think there are a number of scholars that are doing great work in this area. Angela Riley comes to mind. she has a great law review article called Owning Red with Professor Katil and someone else I'm blanking on right now, but that's a great law review article to read. Jane Anderson's doing really wonderful work in thinking about how you know, what sorts of ways there are to catalog and protect Indigenous artifacts. So there's a real materiality to her work that I like to teach in a class that I taught once called Race, Intellectual Properties, and National Identity, where that project is out. That's precisely what we're talking about when we're talking about de-Westernization, or excuse me, decolonization. This second idea of de-Westernization, as Mainiero understands it, is about just shifting political economy to non-Western context, right? So if you have, say, for instance, Chinese competition in the market, or a model for Chinese competition in the market, or Indian competition in the market, that arguably is de-Westernization and not decolonization. So I think that when we talk about these ideas, we want to think about what goals we're trying to achieve and to what extent we are willing to let go of those frameworks of political economy. You know, one of the things that I'm looking at in the second book that I'm working on, which is it's called Creating While Purple. It's about prints and intellectual property rights. One of the questions that I'm thinking about there is, you know, what's Prince's relationship to Black capitalism? Because often Black capitalism is held out as this panacea. Well, it still has the capitalism part, which is why theorists like James Boggs are like, I mean, maybe we need to also rethink the capitalism. We can keep the Black, maybe not so much the capitalism, right? And so what happens when we're in that space? So I'll just throw that out as some folks that are working on Indigenous knowledge, but there are so many doing great work in that area. And I will, I'm guessing Professor Osei-Tutu has words to say here.
I think it's already been very well said. I won't say too much, except that we have to think strategically, because the reality is there are international agreements in place, and the likelihood that these international agreements are going to be dismantled is probably fairly slim. So to me, we have to think about how we can operate within the existing structures or push back on them. And so I like to do that from the theoretical perspective, looking at what are the rationales for protecting certain things and not others. And so that's why to me, something like geographical indications is very interesting, because especially for wines and spirits, it's not about confusion in the marketplace. It's not about anything other than protecting European culture. Or if we think about, for instance, official marks, there are certain kinds of systems we have in place to prevent others from using, even if you yourself are not using that particular identity. So I think there's a lot of good work going on in this space, but I don't know that the answer is to say, well, let's scrap IP altogether. That's kind of to me, I think, you know, we need to be strategic and practical. So I hear where that's coming from, but I would say maybe think about ways to push back on the arguments as to why, you know, a database should get copyright protection, but other things can't. So that I think that's where I would go with that.
I think I missed the blackface question there. So let me go back and address the blackface question. Blackface is woven into a lot of intellectual property. We have spent some time today talking about Aunt Jemima. Aunt Jemima comes from this history of minstrelsy in the United States, and minstrelsy is deeply connected to blackface. So, you know, I think there are overlapping histories where blackface enabled certain kinds of racist caricatures. And to get to that question of anti-Asianness that started us off, a lot of this minstrelsy performance is happening right in the late 1800s, early 1900s, as there's massive, you know, Asian exclusion, anti-Asianness, war on Chinese restaurants, that is really, I think, very continuous in the United States. So blackface is part of the lore, in my opinion, of Aunt Jemima. I think blackface also gets worked into, to a degree, into the conversation about race records, because part of the resistance to race records as mainstream music comes from this notion that there, is Black plantation life, and then there's respectable white life. And Eric Lott has this great book that explores the contradictory feelings of desire and disgust that mark white people's relationships to Black people in this moment of minstrelsy. And I think we still see that today, right? We still see this negotiation of, I want all the good parts of what I understand to be Blackness. I want to be able to steal, Black queer words, or I want to be able to take aesthetics from brown cultures. And also, I don't want to give those people jobs. Right. So there's this both and, this tension that I think can be traced ideologically back to minstrelsy and blackface as a mechanism for reinscribing racial hierarchies at a time when the country was becoming more progressive. And I think there's a literal connection in some of the trademarks that we're talking about, like Aunt Jemima, who literally come out of minstrel shows that involve blackface.
That's great. That one of the questions that I got in the chat was to ask you to elaborate on how tangible mediums of expression may have an impact on people of color in a modern sense. And I think you've just addressed that. So that's really wonderful. Chris Brosnahan, you have your hand up next. And then if you want, I can throw in a question from the chat as well. Hi, Chris.
I guess. So Professor Vats, in your article, you talked about radically reimagining intellectual property law, and I was wondering what that would look like. Are you talking about new statutes or a constitutional amendment? I just think that's a really fascinating area.
And I have a question from the chat that I think might pair nicely with that. And it is asking sort of how, in general, in your experience, when you talk about this book, people are feeling about critical race theory and how it may be different in the classroom, in law school, in college, in high school, and maybe even younger, how people are consuming the concepts of critical race theory.
These are great questions. I like that material, the fixed and intangible medium question, because I think it gets at the history of music oppression in the United States and the way that some people who were literate could write down music and other people could not. The new movie that came out, Ma Rainey's Black Bottom, explores some of these themes, I think, in a really beautiful way. So what does it mean to radically reimagine IP? Well, it means that we get past with this catchphrase, the failure of imagination, right? What does it mean to imagine? I think that's the first question. For me, I think what radical reimagining looks like appears in some of the case studies that I look at in the last chapter. I think Prince does some pretty radical things for being an artist, a Black artist in the moment that he is creating. Changing his name to a love symbol maybe does not get him out of the contracts that he wants to get out of, but that is a radical imaginary moment, in my opinion. It confuses people, and then posthumously people are like, oh, this was actually very brilliant, right? So it may have been illegible in the moment, but I think that there's this revisiting of it that says this is a radical thing that happened. One of the Ross Media Collective, I think is what they're called. They're this artistic group, and part of the work that they do thinks about capitalism. It thinks about how capitalism necessarily leaves human detritus behind as it evolves, as it changes. And so, they're interested as a group in thinking about where the porosity exists in the context of law and where the gaps are for exploiting. So, when I frame this, I like to think about three things. I like to think about the ethical, how we can resituate ourselves ethically with respect to race. This is the thing that people like Derek Bell asked us to do. The second thing is legally, right? So how do we train our teachers or our professors, our lawyers, et cetera, how do we train them to think differently about the space that's presented in front of them, right? How do we teach them to issue spot race issues? If you cannot issue spot race, you cannot fix the race problems. And this is the point that Derek Bell is making, that Kimberly Crenshaw is making, that, you know, Cheryl Harris is making. When your default is whiteness, you cannot see the problem. So I think that is the second thing. And then the third thing is the performative. I like the Prince example and I like the Marshawn Lynch example because I think they demonstrate how performative interventions can actually be really powerful. Everybody noticed when Marshawn Lynch was like, I'm just here so I won't get fined, right? Like that was a big deal because he was not supposed to do that thing in that space. So radically reimagining is precisely that, right? If we map it, it sort of deprives the category of its spontaneity, of its practical power. But I think we can look backwards and say, hey, this is the thing we want more of. And we want to take an approach that perhaps aligns with this notion of fugitivity, with this idea of undoing parts of law, of trickery, right? If we talk about signifying or tricksters or all of these different cultural ideas that help us to approach the law from a new vantage point that's not just like, let's replicate the legal ideas that we have over and over again. Let's cite the same people. And of course, Richard Delgado talks about that in The Imperial Scholar. How are people feeling about critical race theory? I love this question because, you know, Donald Trump tried to ban critical race theory, at least in some spaces, and I found that to be one, terrible, and two, hilarious. Because I can't imagine that the people that are teaching critical race theory are up for getting canceled. I am certainly not. You know, the young people are, my experience, and perhaps you all have different experiences, but young people are very radical. They have lots of space to be radical. They have, they don't have to pay mortgage. They don't have to feed children always, right? I don't want to make generalizations, class-based generalizations here, because I think there's also some elitism, class elitism of that I want to be mindful of. But I think that it conceptually and often materially, young people have more space to be radical than folks do as they get older. So I find that the young folks are like, why can't we go further left than this? And I'm like, I don't know what's further left than this. Like, we're reading racial capitalism critiques, right? It's hard to go further left. We're reading about transformative justice, you know, so they are hungry for it. And also I have a select population of folks. So I teach in, as I said, African and African diaspora studies. So I tend to get 50 to 60% of my class being students of color. And when that's the case, they want to talk critical race theory. That's their embodied lived experience. I will say that my law school has been incredibly supportive of critical race theory. They were excited about having the class. They have been supportive of it being taught every year. So I recognize that there's this thing going on in the world where there is a growing GOP resentment against critical race theory. I said this yesterday at a talk, I will repeat it today, that I think it's based on a profound misunderstanding of what critical race theory is and what it's trying to accomplish. And I think that when students understand critical race theory, especially students of color, that they are very hungry for it. And I am interested to see how much of the radicalism of young folks today is able to stick around. And I think we see that with gender in particular, that the gender ideas that y'all are growing up with are so different from the ones of the 90s. Like, carceral feminism is all we had in the 90s. And this is just such a profound shift. So it feels to me like we're moving rapidly into a world where critical race theory could become a norm. But, you know, I tend to be an optimist.
Any of the other panelists want to weigh in?
I'll just say that doesn't feel true where I live, but I like that idea.
Fair. That is, you're in a hard state for talking about critical race theory right now, for sure.
Yeah, And that context matters, as you mentioned earlier. So I think that's a way to underscore that. Speaking of young and radical, William Merriweather has his hand up next.
Oh, hello. Thank you, Professor Varyani. Can you all hear me?
Yes, and we're going to take your question, William, and then we are going to turn back over to Brie for one last question on behalf of the law review before we conclude. So go ahead, William.
No pressure. All right. I just want to start off by saying thank you to everybody for being here. I haven't read much of anything. I'm only a 1L. And I think my question is based on just that fact alone. Most of the racist cases that we have read so far in our classes don't explicitly say anything at all about race. And that has allowed a lot of my peers to have this idea that the case isn't about race, or it's about whatever legal thing we're talking about. And I guess my question is, how do we address this false neutrality, objectivity of the law? And I guess through this IP lens would be perfectly fine. I'm just talking about in general, but because I don't know much of, okay. But nonetheless, it just seems important because of my experience living in the North and the South. I recognize that the South, generally speaking, explicit racism is much easier to combat and to overcome than the North's pervasive, perpetuated, we're not really racist, we just don't like people like y'all here thing. I think it's important to, I don't know, how do we address that in the legal space?
Yeah, BU had a seminar, 2-day seminar on rewriting the 1L curriculum to include questions of race, and it blew my mind. One of the reasons I do what I do is because I had a similar experience to you. I just remember being in property class and we read Johnson versus McIntosh, and I was like, is no one gonna say anything? And I had that moment where I just looked around and I was like, surely someone's going to say something. And then nobody said anything. And I was like, what's happening right now? So, yeah, I think it's really important to remember that other people are sharing that experience of, what is happening right now with you. And I want to emphasize that your embodied experience of that is real and valid and needs to be heard. And I'm glad that we can provide a space to talk about it. I also think that there is a move in the legal academy to think about these questions differently. I was reading an article about how we don't know how many Black tenured faculty there are. I don't know if that's changed since that article came out, but it was essentially saying that there's not, the statistics around this question are not clear, right? So if we can't even produce demographics for the academy, it's very difficult to fix the problem, right? So I think there are people that are aware of the problem. I think Dean Keller will be able to talk about this at a finer grain about what is being done about it. But my sense of the legal academy today versus when I went to law school is that it is very different. I don't know if I would say radically different. I'm not in that space enough, but I will say that this, in my mind, would not have been possible when I went to law school. I cannot imagine having been part of a panel that was, had this many people of color on it, and women of color no less. So this is a different moment, and I want to stress that. And yes, those classes that you're talking about still happen. And I think when you're 2L and 3L, you're going to find a whole slate of opportunities that did not exist. And there's also room for you to kind of create those spaces. I'm always hesitant to put more labor on the people of color to do the work of building the new structures, but that's what we do, right? It's partly what we have to do. So I think that's happening. I hope that there are more conversations like the one that happened at BU.
I'll jump in here and just say that I do think this is a radically different moment in the legal academy. One of the things that I've seen happen just since I've been here as a dean on July 1 is an ABA project, I'm sorry, a AALS project called the Law Dean's Anti-Racist Clearinghouse Project. It is spearheaded by 5 awesome Black women deans. I am not one of them, in the interest of clarity. I would not refer to myself that way. I want to be clear about that. But really, there is no way that was going on 18 years ago when I was in law school. Nothing even remotely like that. So I do think we are at a moment where talking about race in our profession, and not just in the criminal justice space, but the pervasiveness of race in law in America, that's where we are, right? And so my charge to all of you young folks is run with that, right? Because like Professor Vats said, white supremacy in America is a 400-year-long project. There are lots of bricks to remove, right? And it's going to take lots of hands to build something better in the aftermath of that.
I'm grateful for that question. I'm also grateful for what feels like an advertisement for my critical race theory seminar for all of those New England law students that are here. But yes, and I will also share, I don't think this student is in the class, but I remember last year in my property class, a student raised her hand when we were talking about Glavin v. Ekman. It's a case about views on Martha's Vineyard. And she said, why are we talking about this white people problem case? Right? When there are so many other cases that we could use to cover this very same property concept. And I don't know if that's something that stuck with the other people in that class, but it certainly stuck with me. And it's I'm doing my best to do better by my students, and I get the sense that many others are too. So William, there is hope. So before I turn it over to Brie, I also wanted to give you my heartfelt thanks for being here and for this conversation. Prior to this, I have been on a couple of all women of color panels, but they're usually about talking about what it's like to be a woman of color in the law. And so for this to be a substantive panel about IP is really an honor for me to participate in any way at all. And so heartfelt thanks, especially to Professor Vats, Professor Osei-Tutu, and Dean Keller. And with that, and thank you, of course, to the students who are here, who've planned this, and who continue to inspire me every single day. And with that, I will turn it over to Brie to close the event.
Thank you so much, Professor Varyani. Thank you to all of our panelists for your time and your energy, all of your work and your perspective. I think I will be unpacking this conversation for the next 5 to 10 years. So I appreciate so much all of everything you've provided us with today and everything we can think through. And I do just really appreciate the last few comments acknowledging how far we've come and the fact that we, of course, are standing on the shoulders of giants with this work, but that we also have so much work left to do. So we are already a few minutes over. I do want to respect everyone's time. We would keep you here all night with questions if we could. So I do just, if you have any closing thoughts or would just like to say goodbye or words of wisdom to particularly the law students in the room, but really to everyone, we'd love to hear any closing thoughts if you have a minute before we let everyone go.
I can offer some closing thoughts. So I was reflecting on some of the experiences of 15 years-ish of being past law school and what that looks like. And, you know, Dean Keller and I were reflecting on what they told us at Emory when we were at Emory about becoming law professors. Emory does not have a history of turning out law professors. It was not an option on the table. In fact, I remember the opposite. I remember being told, you know, don't get your hopes up about that. And I never would have imagined that that was a path that I could follow. So the thing I will leave you with is that I really do believe that the impossible is possible. I sort of live by that in all of the best and worst ways that might play out in the world. But I am hopeful, and I know we didn't answer the part of William's question about the North and the South, and so perhaps the two Southerners on the panel would have some different thoughts about this. Though I will say that I think that the East Coast has its own problems of calcification of race and class that we could unpack. So yeah, I will say that, there was so much that I didn't think was possible that turned out to be possible. And I think race and IP is part of that. I think that these conversations in the role of law professor are part of that. And I really do think that there is space for all of y'all to help to shape these conversations and influence the way that we think about law and legality with respect to race.
Dean Keller or Professor Osei-Tutu, not to put you on the spot at all. We could also just let you go enjoy your evening, but wanted to give you the opportunity if you had any closing thoughts.
I just want to say thank you guys really for this forum and for the opportunity to talk about this book. It has provoked a lot of thoughtfulness and a lot of questions and opportunities for further research and thinking and discourse. And so it's been a really productive conversation. And so I wanted to thank you guys for that. And like Professor Vats, I'm excited to see what all of you do in this space, not necessarily the race and IP space, but in helping to envision an anti-racist future.
I would just really quickly say as well, thank you so much for the opportunity to be here. I want to thank Anjali for her book, and I want to acknowledge the very important work that both Dean Keller and Professor Vats have been doing in this space with the race and IP conferences. And I think just having these conversations is really important. And the last thing I'm going to say as we talk about the scholarship that's out there and what we can do is make sure you're also citing the people of color, because, the same way people take over the Black music space and it's popularized, we have people who are already doing all this work and their scholarship doesn't necessarily get cited. It's, they cite the white guy from whatever school. So I'll just end with that. Make sure you cite the scholars of color because there are a ton of people working in this area as well. Thank you so much.
Thank you all so much. Thank you to everyone for being here, for being part of the conversation. Don't forget, if you haven't already, to pick up your copy of The Color of Creatorship and all of the amazing information and links and people who were mentioned in the chat. We're happy to send out a list afterwards to make sure everyone can follow up and continue learning and growing. And look forward to response pieces from all of our panelists in volume 55 of the New England Law Review. Almost forgot that plug. So thank you all so much. We really, really appreciate it. And thank you all for being here.